Good afternoon and welcome to today's webinar, which is a COVID-19 Employment Tribunal case law update. I'm Fiona Herrell. I'm one of the partners in the Employment and Immigration team here at Brodie's, and I'm delighted to be joined today by my colleague, Will Rawlinson. I don't think I really need to say much in terms of the agenda for today's session. I think the title really gives away what we're going to be talking about, but I did want to spend just a couple of minutes really setting the scene. Tribunals are now grappling with COVID-19 related workplace issues, and we're seeing cases coming through with lots of different legal issues at play. So we've seen some misconduct cases, and one in particular involving refusal to wear a mask. There have been some redundancy cases, and in particular around whether or not an employer can fairly dismiss for redundancy in circumstances where it could have made use of the coronavirus job retention scheme. We've seen a pregnancy discrimination case. There's been some cases and arguments around whether the contract of employment can be said to be frustrated. And so sort of a huge variety of cases. But actually, when Will and I sat down to look at the case law, we could see this overwhelming theme of health and safety issues coming through in the decisions. And so what we thought we would do is focus today on health and safety issues arising in employment tribunal cases off the back of COVID. And towards the end of the slide deck, what we've done is set out some of the other decisions that we have been looking at, so that if you want to go away and have a look at those in your own time, you've got the case names and you'll be able to find those decisions on the Employment Tribunal judgment website. So just sort of reminding ourselves of the legal position in relation to health and safety. So starting off, I guess, with the considerations from an employer's perspective. So reminding ourselves that an employer has common law and implied contractual duties to take reasonable care for the health and safety of all workers. And that is then overpinned by a statutory duty under the Health and Safety at Work, etc. Act 1974. And that imposes a general duty on employers to ensure, so far as is reasonable practicable, the health, safety and welfare at work of all employees. But the buck doesn't stop there. It's not just all sitting with the employer. From an employee's perspective, they've got obligations under the Health and Safety at Work Act 2, so it requires them to take reasonable care for their health and safety, and that of anyone who may be affected by their acts or omissions while at work, and also to cooperate with their employer so far as is necessary to enable compliance with any statutory duty or requirement relating to health and safety. And then separate to the legislation, if we think about sort of implied obligations that sit in the contract of employment, we've got the obligation to serve our employer with good faith and also to follow reasonable and lawful instructions. And then just moving on, we're then thinking about the statutory protections that are available for individuals who are either dismissed or treated detrimentally for health and safety reasons. So these are set out in the Employment Rights Act. Section 44 deals with the detriment protection and Section 100 deals with the dismissal protection. Now, in both of those sections, the subsections A to E are the same. I've summarised them on the slide, but that very much is my summary rather than the actual wording of the legislation. So if you are ever in a situation where you need to be looking at exactly what the legislation provides for, please don't refer back to these slides, but have a look at the legislation itself. But we can see that in sort of general high level terms, there will be protection, for example, for someone who raises health and safety concerns through other reasonable means. So that would be in a situation where, for example, there's not a health and safety rep or a health and safety committee, but they raise health and safety concerns through other reasonable means. There might be protection for people who are leaving or staying away from the workplace if they reasonably believe that they are in serious and imminent danger, or for taking appropriate steps to protect themselves from danger which is reasonably believed to be serious and imminent. For detriment, that protection applies to employees, but also notably to workers, and that's been an extension that has only applied from the 31st of May this year, so just flagging that to make sure that's on your radar. Dismissal protection obviously applies to employees only, no requirement for any minimum period of service, so this is not a situation where the employee has to have 2-year service in order to be able to bring their claim. Employees with less than 2-year service also have the protection, and there's also no cap on the amount of compensation that can be awarded in respect of a dismissal for health and safety reason. And that's because if this section applies, the dismissal will be found to be automatically unfair. And it does apply to actual dismissals as well as to constructive dismissals. So that's sort of the framework, I guess, that's sitting behind these decisions that we're going to start looking at. And Will, I'll just pass over to you if that's okay to get us started on this first case.
Perfect, thanks Fiona. So I'm going to kick off with our first Employment Tribunal case, which is Ham against EBSW Limited. And as you'll see, this is a dismissal for refusing to follow instructions. Just to give you a bit of background to this claim and what it was really about. This was a claim for automatic unfair dismissal on health and safety grounds. So as Fiona was just referring to, the relevant section that we're concerned with here is section 100 of the Employment Rights Act. And as Fiona also mentioned, these sorts of claims don't require 2 years service, and the employee or claimant in this case had 5 months service with his employer. His line manager was at home self-isolating due to some suspected COVID symptoms. And this was relatively early on in the pandemic towards spring 2020. She asked him to go and collect some items from a school and then deliver those to her house. Now, there was some disputed evidence, but the claimant apparently challenged whether or not it was really sensible in view of the developing pandemic for him to, first of all, go and collect the items from a school, and second of all, deliver them to his line manager's house, where she was self-isolating due to suspected COVID symptoms. He was then dismissed for failing to follow a reasonable management instruction, which was the collection of the equipment from the school, but also for his poor and inappropriate attitude during a follow-up phone call with his line manager. Now, the claimant's evidence was that his line manager had contacted him and instructed him to collect the equipment from the school. He asked where he was to store it because his van was getting full. She told him to deliver it to her house. He then asked whether, in view of the travel restrictions, the collection was essential and whether it was wise to deliver it to her house if she was self-isolating. He says that his line manager became extremely rude and overbearing, and he said that it was never a refusal. It was simply a question of, is this the best thing to do considering the circumstances? He also said he felt he had no choice but to attend her address. The respondent said, well, they agreed that they did ask him to collect the equipment and that he did question whether it was essential to do so, but they denied that he made any reference to COVID-19 or that he raised any specific health and safety concerns. They explained that the line manager told him she would leave her garage door unlocked so that he could drop off the equipment without the need to actually make any sort of physical contact with her or be anywhere near her. And that it was the claimant who had raised his voice in an aggressive manner and had ended the call abruptly. A little bit of a he said, she said here. And the claimant the respondent said that the claimant had also previously picked up keys from a separate employee who was self-isolating and had been visiting several other client sites and hadn't raised such concerns about those tasks. The line manager did accept that there had been some discussion on the call about her self-isolating, and she conceded that the claimant did raise health and safety concerns, but in relation to going to the school and not coming to her house. She maintained that the main issue here and the reason for the dismissal was the claimant's attitude. And if we move on to the next slide, we can see how the tribunal approached this. So the tribunal preferred the claimant's evidence, in short, and they concluded that the dismissal was, at least, in part, if not for the principal reason of the claimant raising concerns about his health and safety. They said, there may have been some element of irritation on his line manager's part as to the claimant's alleged tone, but that concern would not have arisen independent of the health and safety concerns raised by the employee. Now, as I said, the timing, this being earlier on in the pandemic, and the lack of knowledge about the situation was recognised by the tribunal because this case was heard somewhat later down the line, but they decided that those were not any excusable factors. And what they've said, and I'll quote this, in the context of the uncertainties and fears of late March 2020 and the death toll since then, It is inconceivable that an employee being instructed to go to a house where 2 people were self-isolating with suspected COVID symptoms was not raising concerns that he reasonably believed were harmful or potentially harmful to his health and safety, or that he was seeking to take appropriate steps to protect himself from danger in circumstances in which he reasonably believed to be serious and imminent. And if you recall, that's the statutory language that Fiona had mentioned earlier on in the Employment Rights Act, which protects people from raising such health and safety concerns. And in this case, the employee was awarded 1 year's salary. He wasn't a particularly high earner, but it was still £16,640. And there were no deductions made to that or any failure to mitigate his losses because he'd applied for over 50 jobs. So that's one case in which we can see that not having the service 2-year service doesn't matter. It really is focused on what did the employee raise concerns about and how did the employer respond. And if we move on, I'll cover the next case, which is Gibson v. Lothian Leisure. And this is a dismissal over concerns about a lack of safe working measures. To give you a bit of background about this one, another claim of unfair dismissal, but also involved unlawful deductions, claim for notice pay and for holiday pay. And again, the claimant did not have 2 years service in this case. The respondent didn't enter a response and didn't appear at the hearing, so we probably need to bear that in mind in terms of how successful they might have been or what their chances really were in terms of winning. But nevertheless, the claimant did submit a claim. He had previously worked as a chef in Dalkeith, and he was furloughed by the respondent towards the start of the pandemic. And he said that there were no employment issues prior to that, so he hadn't had any sort of performance or conduct concerns raised. His father had a brain tumour, suffered from colitis, and also had Addison's disease. And so prior to the first lockdown ending, the employer had asked the claimant to undertake some work, coming in and helping out for a bit. And in view of his father's condition, the claimant raised some concerns, specifically that he thought he might catch COVID and then bring it to his dad when he came back from work. He said that the respondent had provided no PPE and that there was no intention of requiring staff to take any precautions, social distancing or anything like that, in order to create a secure working environment that was COVID-free. He also maintained that his employer's response to him was robustly negative and that he was told to shut up and get on with it. Very sympathetic, clearly. So he says that his employer started to see him as a bit of a nuisance by raising these concerns, and that his employment was then terminated without any discussion or any process. In fact, the only correspondence he received from his employer was, and I'll just quote this, "Moving forward, we've decided to terminate your employment with ourselves. We are changing the format and running of the business on a day-to-day basis, and at the end of the lockdown process, we will be running the business with a smaller team. Thanks for all your efforts in the past, and I wish you well for the future." If we go to the next slide, we'll see how the tribunal assessed this. So this claim was for whistleblowing, but also for an automatic unfair dismissal under Section 100. Now, the tribunal made sort of short shrift of the whistleblowing claim. They decided that the claimant hadn't actually made a protected disclosure. I won't go into too much detail about that because that's obviously not the purpose of today's session. But they then turned to Section 100 of the Employment Rights Act. And they were satisfied that the claimant's actions did meet the requirements of that section. And they said, the circumstance of danger was the growing prevalence of infections by the COVID-19 virus and the potential significant harm that could be done to the claimant's father should he contact the virus from the claimant. And the claimant reasonably believed this to be serious and imminent, hence raising the issue of PPE. And the raising of that issue amounted to an appropriate step to protect his father from that danger. They also decided that if he wasn't dismissed for having raised health and safety concerns, he was nevertheless selected for redundancy because of them. And so he was either automatically unfairly dismissed under Section 100 or a separate section of the Employment Rights Act, Section 105, which deals solely with being selected for redundancy for having raised health and safety concerns. Now, he was awarded over £6,500 as a basic award, £14,500 as compensation, £1,200 for accrued holidays, over £800 for accrued wages, and £500 for his notice. So in total, it came to just over £23,600. So again, not an insignificant sum. And I'll pass back over to you, Fiona, for the next couple of cases.
Great, thank you. So we'll have a look at Rogers. So this is dismissal for leaving workplace over concerns about infecting the employee's children. So the facts of this case: Mr. Rogers was employed as a laser operator between June 19 to April 20. So again, relatively short period of service. The pandemic hit. The employer undertook a risk assessment in relation to the workplace. They did that by virtue of engaging external health and safety consultants to come in and to do the assessment, to write a report with various recommendations. And the employer then implemented a number of the measures that had been recommended, including social distancing, enhanced cleaning, provision of masks, and staggered start and finish times and breaks. Mr. Rogers ultimately developed a cough, and so he self-isolated for a period of time. Before he was due to return to work, he texted his manager to say that he'd be staying away from the workplace until the lockdown has eased, was his wording, because he was worried about infecting his vulnerable children. And he had a very young baby and also a child who has sickle cell anemia. Now, initially, the line manager seemed pretty unconcerned at Mr. Rogers' stance in response to the pandemic. But a month later, Mr. Rogers was dismissed. His employment was terminated by the employer. He raised his claim of automatic unfair dismissal, relying on the provisions around staying away from a dangerous workplace and taking action to prevent danger. In terms of what the Employment Tribunal made of that, ultimately they found that his claim was unsuccessful. And that really stemmed from the fact that when they did their sort of factual inquiry and they stress tested Mr. Rogers' evidence, he wasn't a particularly compelling witness. I think a lot of his evidence was contradictory. He'd submitted a claim form, there'd been a couple of applications to amend, and then at the hearing his evidence was slightly different again, and that obviously that's going to factor into any tribunal's decision making when they see that sort of fact pattern. But here they did not think that there was a reasonable belief on Mr. Rogers' part that there was a serious and imminent workplace danger. They took into account the fact that he worked within a very large warehouse type space, and that typically had only 5 workers on the shop floor at a time. So from a social distancing perspective, for the vast majority of the time, that was going to be possible. And the claimant did concede that in his evidence. There was mixed evidence as to just how large the warehouse was. One of the witnesses talked about it being the size of half of a football pitch, but certainly it was the tribunal made a finding, it was a large space, and that social distancing was going to be possible. The tribunal also reflected on the fact that, the employer had acted responsibly. It engaged the external contractor to come in to do the assessment from a health and safety risk perspective. It then implemented the measures, including hand washing and talking to employees about the need to socially distance within the workplace. But it then sort of looked at some other factors too. So it took into account the fact that Mr. Rogers had breached self-isolation. So when he didn't attend work because he had a cough and decided that he was going to, or not decided, but was required to self-isolate in accordance with the guidance at the time, he had taken the decision to drive a friend of his to hospital. Now, the evidence he gave on that was that he had sat obviously in the driver's seat with a mask on, and that the friend had sat in the rear of the car also with a mask on. But nonetheless, that sort of obviously factored into the Employment Tribunal's decision making. And they also considered that when he had texted his manager, he didn't mention any concerns about the workplace. So it wasn't, I'm not coming back until you have fixed A, B, and C. It was, I'm not coming back whilst sort of the pandemic is ongoing. Nor had he taken any steps to raise concerns with his manager before he went off. So during the tribunal hearing, he gave evidence about the fact that sometimes there was a a mask dispenser that didn't have any masks in it, or maybe there wasn't sort of sanitizing gel in the hand sanitizing stations. But again, there had been nothing raised by him at the time when he was in the workplace to say, I'm concerned that these measures aren't being implemented properly. Ultimately, therefore, the tribunal found that his decision to stay off work was not directly linked to his working conditions, but instead his concerns about COVID-19 more generally, and that was why his claim failed. I think this one, this decision is a good example of the importance of doing your health and safety risk assessment, of course, implementing the appropriate health and safety measures that you need to within your workplace, but also communicating them to the workforce so that your employees and your workers understand what measures you've put in place and why you've put them in place. And that's definitely going to be able to help defend any claim of this nature that might be brought against you. We move on to the next case. This is a Catus, and this is dismissal of an employee who wanted to be furloughed due to concerns regarding COVID. So in this case, Mr. Catus was a sales and project coordinator for a PPE distributor from May 18 until April 2020. So he was just at that point where he was about to get 2 years service. His role was one that could not be performed from home. His employer had again implemented various COVID-19 measures within the workplace, and that included increased cleaning, social distancing, and hand sanitizers. And the employer was able to produce very clear evidence to the tribunal of the communications they had issued to their employees around these measures and the other approaches and stances that they were taking in response to the pandemic. Mr. Catus ultimately developed COVID symptoms and he self-isolated. Initially, I think he thought that he would be out of the workplace for a relatively short period of time, but ultimately his symptoms continued. And the longer they went on, he was becoming increasingly concerned about his ability to pay his bills. So he went to his employer with a proposal that he be furloughed. The Corona Job Retention Scheme was in place at that point. Now his request was refused, and the employer's position on that was there's plenty of work, so we don't have a basis for furloughing you, but we will offer you unpaid leave, and that was the position that they were offering across the business. So that was for anybody who wasn't able to come to work, they could either take paid leave or they could take unpaid, they could take paid holiday or they could take unpaid leave. Mr. Catus was sort of quite up in arms about that. He refused to take the unpaid leave and he issued an ultimatum, which was that he'd be furloughed or he'd be allowed to work from home. Now, at this point, he mentioned that he was uncomfortable using public transport and being in the office during lockdown. Shortly thereafter, he was dismissed, so he didn't return to work, but nor did his employer concede to his request to be furloughed, and he was ultimately dismissed. And the correspondence that was issued to him said that the reason for the dismissal was a general ongoing failure over a period of many months to support and comply fully with our company policy and guidelines. So in terms of what the tribunal made of this one, there was evidence that Mr. Catus was a good performer. However, there was also evidence that he was a difficult and challenging employee who made frequent complaints about his working conditions and that his working relationship with his line manager had become quite strained. The question was put to the manager who took the decision to dismiss about the significance of the fact that Mr. Catus was about to reach 2 years service, and it was conceded by the respondent that that had played a part in their decision making in deciding to bring Mr. Catus's employment to an end. So in terms of thinking about Section 100 and whether or not there was serious and imminent danger here, the tribunal accepted that the pandemic meant that there were circumstances of danger that Mr. Catus could have believed to be serious and imminent, and that he did believe the danger to be serious and imminent, but that he didn't take appropriate steps to protect himself and others from danger. So he could have taken steps to self-isolate, to social distance rather within the workplace. He could have taken steps to raise concerns that he had about masks, about sanitising gel and so on, and he didn't do any of that. But anyway, all of that turned out to be academic, because when the tribunal drilled down into the real reason for dismissal, And obviously, these provisions will only kick in if this is the sort of the principal reason for the dismissal. Ultimately, what the tribunal said was that the real reason for dismissal was not the fact that Mr. Catus was refusing to attend work, but rather his antagonistic relationship with his line manager and the fact that he was about to achieve 2 years service. And therefore, because he didn't have the 2-year service and because he couldn't get over a Section 100 hurdle and satisfy the test there, his claim ultimately was unsuccessful. So I think that was just a reminder of thinking about what the real reason for dismissal is, which takes us into our lessons we can learn. The important thing with all of these decisions are they are first instance decisions of the Employment Tribunal, which means that they're not binding on other tribunals. And of course, they will all turn on their own facts. So it's more about thinking about the principles that we can distill from these cases rather than treating them as binding authorities. Obviously, these cases tell us that putting in place robust measures in line with the prevailing government guidance is important, but actually so too is the communicating the measures that have been implemented and why. And that's going to be particularly important for businesses who are perhaps at the stage of thinking about a return to the office, aren't quite there yet. You really will want to make sure that you are communicating to your workforce the measures that you've put in place and why you've put them in place, and what people should do if they have any concerns about any alleged inadequacies or failings that they might spot. If people are raising concerns of that nature, it's going to be really important that you listen to them, that you've got a forum for that, whether that's sort of a line manager or if it's going to a particular team, whether that's your HR team or health and safety team, or it's perhaps a group of a working party that's been put together with a mix of professionals from across your business. But whoever it is, that they listen to those concerns, that they carry out such investigations as are necessary, and that if you do spot there are failings or inadequacies in your measures, that you take steps to rectify them, so that you can then go back to say, you told us that the hand sanitizing gel in the reception area is quite often empty. We have taken this measure in order to remedy that, and we hope that that sort of satisfies your concern. So what we're trying to do is get to a position where it's not going to be possible for people to say, I'm not coming back to work because I've got these health and safety concerns, or I'm taking myself out of the workplace because of these concerns. If you are in a situation where you're dismissing, obviously you're going to want to think about whether it's possible to do anything other than dismiss. So, for example, could you redeploy to a suitable alternative role, or might there be a possibility of accommodating paid leave? If you are going to dismiss, then just be thinking very carefully about what the real reason for dismissal is. So again, going back to that sort of a Catus decision, is it a decision that you're taking because the person is raising health and safety concerns or doing any of the other sort of protected acts that are set out in Section 44 and Section 100 that we've looked at, or is it for another reason? If it is for another reason, please make sure that that's absolutely clearly documented, because the individual may well challenge the fairness of their dismissal based on them saying it's for a health and safety reason, and you're going to be able to want to defend it on the basis that it wasn't. It was actually for something completely unrelated. In terms of the final slide, then, these are just the other cases that Will and I were looking at in advance of the session, which we decided not to cover today, but we thought it would be helpful for us to signpost those to you so that you can have a look at those. I can see that there have been some questions coming through. Well, I don't know if you've had a chance to have a look at those and if there's any that you want to pick out.
Yeah, thanks, Fiona. One question we've got here is, can an employee be dismissed or subjected to disciplinary proceedings if they refuse to attend work because of health and safety concerns about their commute? Okay.
Good question. I guess sort of the Catus decision kind of touched on that, in that Mr. Catus was saying he didn't feel comfortable using public transport, but ultimately the tribunal didn't have to make a finding on that because they found that the reason for his dismissal was actually the poor relationship with his line manager. I think it's certainly possible that the protection under Section 44 and Section 100 could be broad enough to extend to a commute. There was one case a number of years ago, pre-COVID, which was about prison officers who had to travel along an icy road in order to be able to get to their place of work. I think the slight wrinkle with that case and the hesitancy around whether or not it would be a binding precedent in relation to current circumstances was the fact that the employer provided the mode of transport to do that commute. So arguably, or there might have been an argument that was an extension of the workplace. But I think it is possible that the commute could be covered. What I would say in relation to the commute is where you might get to is circumstances where you're exploring with the individuals what appropriate steps they could take to avoid the danger. So, for example, if they would normally take the bus, is it possible that they could drive instead and therefore be in their own car and not have to take the bus? Or could they walk to work instead? Could they wear a mask? Are there other things that they could be doing? But it is possible that the protection will extend to individuals in that circumstance. I think it would be to proceed carefully if you are thinking about disciplining or dismissing somebody who's refusing to come to work because they're concerned about the commute rather. Conscious of the time, we've run over slightly, so I think I'll just bring us to a close there. Thank you all very much for joining the session. There will be a prompt that comes up automatically which asks you to complete a feedback form. It's 5 questions, less than a minute to complete, but it really does make a big difference to us in terms of planning future topics and sessions, and also for giving us feedback on how you think we've done today. So if I could ask you to complete the feedback form, that would be very much appreciated. But otherwise, thank you very much for joining and have a good afternoon.
Thanks.